You were president of the New South Wales Bar Association between 1998 and 1999. Do you think during that time there were particular initiatives you brought to the fore, or emphasis or change in emphasis in bar policy, or anything that you feel were a result of your time as president?
I kept my head down. I was lucky enough to avoid scandals. And after I finished, poor Ruth McColl was president, and she copped the great tax scandal, which fortunately I was able to avoid. The biggest fight we had with the government was the fight about motor vehicle injuries and green slips and the cap on damages. And
You have been quite prolific as a writer, and written strongly and passionately about a number of things. And of course, as well, you've been a member of the International Human Rights Observer Panel, established in 2005, and you did write about what happened in Guantanamo Bay and afterwards. So you have a strong civil liberties streak in all that you do, I take it.
yes, that's partly true. I don't like politicians and bureaucrats who get together and pass almost mindless laws in the pretense that they're necessary for the continuing existence of the community.
What being a particular example?
Or the anti-terrorist legislation, which was very much abused in the case of Dr. Hanif, the bikie legislation, which is just crazy. I wrote about that too. Have you got?
Yes.
Yeah.
Yes. In their shoes, though, I ask this because I interviewed the late Victorian governor, Richard McGarvey, and he spoke to me, having been both a politician and obviously he went on to become a judge. He said it is very interesting how institutions mould people. And I think in a sense he was commenting on how it was being a governor at the time. Would you agree with that? In other words, if you had been in a different situation where you were having to draft this legislation, perhaps, would you have thought differently or the same?
I think I've thought the same, because it's not hard to see the almost contemptuous waiver of matters of high principle, which we used to take for granted. I mean, it was entirely unheard of that somebody not even suspected of a crime could be arrested and interrogated for 7 days by ASIO, which can now happen. And it happened, in the blink of an eye. That nobody in Parliament seemed to be very interested in this awful intrusion on our ordinary, fairly hard-fought rights.
So you see it as a slippery slope.
Yeah, I do. It's not going to get any better, I don't think.
Has there been any attempt to heed what you've written in parliamentary circles?
Don't think so. Not that I know of.
Others share your concerns, though. Is there some attempt perhaps to form a larger body that might, for all I know, be able to lobby and perhaps bring about, if not a complete reversal?
The Law Council and the Australian Bar Association, I think, both did just that.
But to not enough avail?
Don't think so, no. No, I can't see the Labor Party under McClelland as Attorney General doing anything about it.
Have you petitioned them directly yourself?
No.
That's one of your big concerns, a slippery slope example. What are other slippery slopes that you're observing from your vantage point, looking back over your career, knowing what you know? I know, for example, you've commented on the intrusion of the media in the case of Marcus Einfeld in recent times, and the media, in a sense, it's trial by media, I suppose is what you would call it.
Yeah. I think a major concern is the gradual shift towards removing the presumption of innocence, which you get particularly in relation to sexual assault cases. And in fact, in that thing that was published in the Bar News, I'd set all that out. I mean, for example, and it's only an example of many such things. If a man is convicted of rape and the conviction is set aside and is retried, the complainant is not required to give evidence. The Crown simply tenders the evidence from the last trial, which is just grotesque. I mean, what happens if his counsel at the first trial had been entirely incompetent and forgot to ask questions? The American Constitution provides specifically for a person to face his accusers, but that's becoming less and less the norm.
There are often arguments, and you would have heard these arguments too, that it is often difficult for a complainant, particularly in a rape case, to face their supposed attacker because they always describe it as being like being raped again.
It's a terrible problem, and I've got a lot of sympathy for women in that situation. But the question is, do we now assume that every complainant is telling the truth? And I suppose most women who complain of sexual assault are telling the truth. There's no way of knowing in any empirical way. But to say that is to say, well, if we accept that, let's forget about the onus of proof and the presumption of innocence, and let's extend it to other cases. Why bother with juries? Eventually juries will go, I think, for that reason.
Do you really feel that?
Yeah. They were finally almost abandoned completely in civil cases, except for defamation, without much resistance. Well, it was a process that took about 10 years, I suppose, but government after government gradually whittled it down, and so now there is, whilst there is provision for juries, both in the state courts and the federal court, the legislation is quite specific that the ordinary course of events will be a trial before a judge alone, unless there's some special reason why there should be a jury. And
so in other words, we're heading towards the inquisitorial system.
I suspect so. I do suspect so. Some people think it'd be a good thing.
You don't?
No. I just could not get used to the idea of a judge being given a dossier which gradually piled up day after day, full of stuff which might be true, might be false, might be gossip, might be scandal. And
So I wonder, because it does represent big questions for the Bar Association generally, barristers in all states, wither, if you like, the profession, because there have been a number of media columnists, and you would recall in particular persons like Evan Whitten, for example. Evan Whitten has written extensively about the pluses, as he sees it, of the inquisitorial system and the like. And while people like yourself and Chester Porter, who I interviewed the other day, are strong advocates of the jury system and the importance of it in a democracy, there seems to be almost a view that emerging, not a necessarily the right view, but a view in the public discourse that there's something wrong with the way the law works and the system of justice works, and maybe somehow this will be preferable. What do you say, as someone who knows the system as well as you do? How can barristers and judges, of course, who can't really exactly answer back, how do they not only withstand that kind of attack, but most importantly, put forward as strongly as they can and as eloquently as they can the importance of the system that we have now?
Well, I did it when I had a running battle with Whitten for a couple of years. Well, that's one of the things I did when I was president, actually. It's very hard to explain to people. I mean, one of the reasons for attention of the jury system is that it's the only avenue left whereby ordinary people take a direct part in government. And I wouldn't like to see trial by judge alone universally. It frequently happens. It's not often known in all the criminal cases in New South Wales in any 1 year, maybe 2% would be heard by a jury. And that's because there are so many statutes which create criminal offences which are tried by a judge alone, such as the Land and Environment Act, the Industrial Commission Act, or whatever it's called, various statutes relating to pollution, apart from those, most people plead guilty. Most of the rest are tried they either plead guilty or tried by a magistrate in the local court. Some go to the district court and plead guilty. The rest is the small remnant, really, of all those cases, which are tried by jury in the Supreme Court or the district court. So one day someone is going to say in Cabinet, why do we muck around with this tiny little group of ne'er-do-well people who insist on disrupting the system by demanding 12 people try them? We're safe in respect of Commonwealth offences unless the Constitution is amended, because, as you know, a trial by indictment will be by jury. Now, a government can avoid that to an extent by making more and more serious cases triable summarily, but it's a safeguard which the states don't have.
Do you have thoughts, and you've written eloquently, obviously, about democracy and trial by jury, do you have thoughts about how better to get the public to understand and thereby, if you like, uphold the necessity for continuing that tradition? How can the bar work to persuade the public, if you like, of the importance of upholding that tradition?
I don't know. The part of the problem is that if someone is acquitted after a notorious case, there'll be screams of anguish. Various people will say they're devastated. It's the N word these days. Then if a person is convicted after a notorious trial, there'll be screams of anguish the other way. It's very hard to satisfy everybody. I don't know what the reaction was to that Stewart case. He was acquitted yesterday, I think. I don't know whether people like serving on juries. They probably find it interesting for the first day. We don't treat the jurors well enough. That's one thing I'm quite certain about. We don't pay them enough. We don't give them proper accommodation. So there's no incentive for an intelligent, well-paid person to sit on a jury.
So if this were remedied, we might see perhaps, in a sense, a bit more, I suppose, public upholding, if you like, of the importance of the jury system just by virtue of the fact that it's worth people's while more so to sit in a jury.
Yeah.
I mean, it is a hard question, I realise, in putting this to you, but it is an interesting one right now because you yourself are very aware of it, and there's a great deal of commentary around and perhaps not much enlightenment, I suppose. Just in final, Ian, looking back over the years and calling to mind all that you have done, how would you best sum up what you feel has been the best of your time at the bar and as a barrister? What to you has been the best thing in terms of achievement in your life?
It's almost impossible to answer.
Or if you like, how would you like to be remembered?
I'd like to be remembered as a barrister with, who didn't cheat. That'd be my primary desire. And secondly, to be remembered as a competent advocate. I don't know what else I could ask for.
That's a very modest assessment. A man of integrity, in other words.
That might be putting too high a bar. Yes.